Hello, everybody, and welcome back to the Law Academy, focusing on the subject of land law in this lesson. We're going to move on to topic number 6 in this video. This video beginning an introduction to the subject of leases. We're going to take an introduction, like I said, to what leases are in this video, the distinguish between a lease and a license in this lesson as well, before talking about the essential characteristics of a lease in the next video, which is, of course, the subject of the case of Street and Mountford. So, fundamentally, topic 6 concerns ourselves with the subject of leases, the leasehold estate. We'll talk about what a lease is, the different types of lease that exist, as well as some of the key questions relating to the bringing of a lease to an end, as well as the issue of forfeiture of leases, which is often one of the larger topics that are often cited in exam questions when it comes to the topic on land law. We will then move on in topic 7 to looking at licenses and proprietary estoppel. Topic 8 will look at easements. Topic 9 will look at freehold covenants. And then topic 10 will look at mortgages. So, leases, or sometimes described as the leasehold estate, which is, of course, the distinction between a leasehold and a freehold, is a legal estate which is registered under Section 1 of the 1925 Law of Property Act. It is one of the legal estates that is cited as per Section 1 of the 1925 Act, and of course is something that is that exists as quite a substantive legal right in conjunction with that of the freehold estate, with the fee simple. The leasehold estate differs from the freehold estate in the sense that when we think about the freehold, there will be an entitlement to property for essentially an indefinite amount of time, to essentially represent what would be described as a near complete ownership of the property, despite the fact that, of course, by technicalities and in technicalities, you do not technically own land in England and Wales. You own estates in land, and that all land is owned by the Crown. If you have access to and you have ownership over a freehold estate, then you essentially have the entitlement to that property, and it's an indefinite entitlement to that property. However, when it comes to a leasehold estate, when it comes to the lease, the time period in which you have access to that property is actually one of the key determinative delineations that is made. You often will think about the delineations that are made between leases and other types of interest in land in terms of the duration, in terms of the time period in which that lease is actually available for. That is what determines and delineates, should I say, the distinction between the leasehold and the freehold. You can then make a distinction between a lease and an easement, or any other kind of interest of that kind of nature, as well as a distinction between a lease and a license. The distinction there being, of course, one is a legal estate, one is only a proprietary, a personal right. So, the leasehold estate entitles an owner to have an exclusive possession of the property for the duration of time that is specified in the lease itself. So, where we are talking about what kind of rights you essentially have almost all of the rights of a freehold owner for a specific duration of time. It is the time difference that is what delineates the leasehold from the freehold. Now, the lease agreement, of course, determines the type of lease that we are going to be agreeing upon. It also determines the length of time in which the lease will last. Some leases last for a year, some last for 100 years, some last for 999 years, which is quite an interesting understanding of the technicalities of land law in relation to leases. Now, I wanted to finish this introductory lesson by talking about a case from 2000, the case of Bruton versus London and Quadrant Housing Trust Limited. This case, the claimant sought to have his agreement made with a trust owning property to be recognised as a lease rather than merely a licence. The reason why you might want to do so is because when you recognize something as a lease, if something is determined to have been a lease, it grants the leasehold owner more rights over the property, more proprietary rights, in fact, than a mere license holder. Licenses are not particularly very strong in terms of the rights that they ascribe to the person who holds the license. The reason for this was, if it was to be considered a lease, the defendant in question would have to have the upholding of their statutory duty to repair some parts of the property. This is part of Section 11 of the Landlord and Tenant Act from 1985. So basically, you have a claimant who has a property, who has a certain amount of control or ownership over a property, and the defendant, the landlord or the alleged landlord, should have made a number of repairs. If it was only a license, then this repair duty is not a statutory duty. It is not part of the Landlord and Tenant Act. However, if it is a lease, then they will be required, as part of the Landlord and Tenant Act, to uphold their obligations as a landlord to be able to make a number of repairs with regard to some parts of the property. In reality, the trust owning the property did not have the statutory duty to grant leases. In fact, they only had the authority to grant licenses. And so really the first initial question that you should think about is the maxim in law that you can't give what you don't have. So essentially, if you do not have the authority to grant a lease, then how can it be anything more than a license? It has to have only been a lease, which therefore would represent quite a simple conclusion to this case. It would represent a conclusion to this case that is in line with the basic principles in law that you can't give what you don't have, and so as a result of which, if you do not have the authority, the power, the ability to create a lease, how could you create a lease? Is essentially the question that is asked by the court. In addition to this, in addition to the statutory power that the trust owning the property had only to grant licenses but not to grant leases, the agreement in question was very clear that it was intending to grant a license and not a lease. This is something that we will get to at various points throughout this series of lessons. The extent to which an agreement which is, by all accounts, described as or intended to be a license, the extent to which that actually protects individuals against claims that in fact it is not a license, it is in fact a lease. Because in some circumstances we find that even though the agreement is called a license agreement, and even though it says this is a license, if by all accounts it represents the rights that are ascribed to an individual who has a leasehold, essentially if it acts like a lease, even if it is called a license, the courts will find a lease in those circumstances. The Court of Appeal essentially rejected the claimant's argument, owing to the lack of intention to create a lease, in addition to these numerous other factors. So not only there was no intention to create a lease on the one hand, but there was also no authority on the part of the trust that owned the property to be able to even grant a lease. It could only grant licenses, and it was intended to grant a license, so it could only have been a license. However, the House of Lords overturned this ruling. Instead, they held that this was indeed a lease. And because it was a lease, it fell into the scope of Section 11 of the Landlord and Tenant Act of 1985, and as a result of this meant that the defendant would have a statutory duty to make a number of repairs in regards to the property. This is a very controversial case, because what this does is it seems to strike against one of the most foundational principles of law in general, which is this idea that you cannot give what you do not have. If you don't have the authority and the ability to grant licenses, how can you grant leases? How can you grant something that is then therefore a lease? It seems silly to do. It is also one that seems to strike against the intentions of the party in the creation of a lease or a license in this regard. What it essentially tells us, however, is that an intention to create a license and all of the factors which are considered here, like the name of the agreement being a license agreement versus a lease agreement, okay, all of these factors do not necessarily negate the characteristics of the right that the person who is the claimant they may have as a leasehold. So even, like I said, even if it is called a license agreement, if it has all of the characteristics of a lease, it will be found on the basis of the facts to have been a lease rather than a license. This is one of those interesting quirks within land law that we're going to get to in future lessons' time. So in previous lessons, we've been discussing the nature of the lease, the leasehold estate. Now, this lesson is going to spend a little bit of time talking about the major characteristics of the lease. Now, this will be useful to keep in mind for the duration of our lessons when we talk about the lease, especially when we talk about the different kinds of leases, given the fact that there are some discrepancies between what is considered to be the essential characteristics of the lease as established in the case of Street and Mountford on the one hand, versus some of the different types of leases which may or may not fit nice and neatly into the mold of these characteristics on the other. So that's something that to keep in mind when we go through this lesson. But fundamentally, as a spoiler alert, we're going to be talking about the case of Street and Mountford, the case of Street and Mountford giving us an indication of what are the essential characteristics of a lease, what is required for a leasehold to exist. In the previous lesson, we finished by noting, referencing the case of Brunton versus London and Quadrant Housing Trust, that an intention to create something that isn't a lease, i.e. to create something like a license, does not actually necessarily preclude an agreement from being a leasehold agreement. Now, this is something of an interesting point. It's something of a controversial point, because what this case essentially involved was the giving away of something that that person didn't have, which is obviously a basic tenement of law, that you can't give that which you do not own. But nevertheless, this is one of the cases that illustrates the point about leases, mainly the point about something being a lease, whether or not you intended it to be a lease or not. The intention of the parties, so long as it looks like a lease and it sounds like a lease and it walks like a lease, then it will be a lease. That's the kind of point that is made. So the intention to create a lease does not necessarily preclude an agreement from being a leasehold agreement. The reason for this is because so long as it has the certain and distinct characteristics which are necessary for the existence of a lease, then it can become one, or it can be one, even if, like I said, the intention does not necessarily suggest that it is. And so we can draw on the case from Street and Mountford to identify what these various different characteristics actually are. So what are the characteristics and the requirements for the establishment of a leasehold estate? So the case of Street and Mountford from 1985 is an illustrative authority on this question. It gives us the indication of what is or at least what are the key characteristics of a leasehold. The case specifically, in terms of the facts, involved Street, who had a written agreement with Mountford, which gave the latter, Mountford, exclusive occupation of Street's house. The agreement itself was actually intended to be a license, and all the deliberate wording suggested as much. So it was considered to be a license agreement. It was expressly clear that it was a license and not a lease. Okay, so think back to the previous case and think back to our previous discussion about whether or not intention actually necessarily matters, or whether or not it necessarily is a good indication as to whether or not something is or isn't a leasehold. When a dispute arose whereby Street sought to terminate the agreement, it was argued that in fact it wasn't a license, and in reality it was a lease, because as a result of which, if it was found to have been a lease, then Mountford would be would have certain rights under the statutory requirements of the Rent Act from 1977. So essentially, if you have a lease rather than a license, then you have certain other rights which exist over your particular occupation of a property, rather than necessarily that you have more rights as a leasehold, owing to the proprietary nature of the right, rather than the just simple non-proprietary nature of a license. They argued that it was a lease, not necessarily owing to the fact that there was an intention to create a lease, but rather because it granted exclusive occupation of part of the property, namely of 2 rooms within the property. So they made the conclusion that essentially you may have called it a license, but in fact what you had created was by all accounts a lease, owing to the characteristics of it. And so when Street argued that the idea of exclusive occupation could still be a license if the parties intended it to be an agreement of such, the courts had to determine A, what were the characteristics of a lease, and then B, whether or not this actually fell into those characteristics, and therefore meant that there were certain statutory requirements that Street had to uphold. It was held that, by the House of Lords, the agreement was in fact a lease and not a license. So despite the fact that there was an intention to create a license, and this intention was expressly stated there throughout all of the agreements, all of the paperwork, for example, it still was nevertheless a lease. Lord Templeman outlined the basic characteristics of a lease in the judgment to this case, and they said that these are the following characteristics. Firstly, there has to be a certainty of term. This relates to the sort of temporal nature of the leasehold. Remember, the distinguishing feature between a leasehold and a freehold is the fact that with a freehold, you essentially have an indefinite amount of time for which you have exclusive possession of the property. Whereas when we talk about a leasehold, you have what is known as a, quote, slice of time. There's a certain duration, a certain period of time in which you have access to and exclusive possession over that particular property. So certainty of term is a key characteristic of a lease. The second is this idea of exclusive possession. Exclusive possession, of course, is something that distinguishes a lease from a license. So a license does not necessarily have this exclusive possession, exclusive occupation of the property, whereas a lease, owing to the proprietary nature of that interest, proprietary nature of that right, they do have exclusive occupation of said property. And then there's the final characteristic, which is the payment of rent. There has to be a payment of rent, which obviously is payable by some kind of value, often money, which obviously represents the payment of the leasehold. Now, the extent to which this is necessarily a requirement is questionable in today's law, because you could theoretically have a leasehold that does not have the payment of rent, or maybe has quite unusual and unexpected forms of rent payment. But for the most part, you will pay rent when you have a leasehold. But in terms of the absolute and the necessary requirements for a leasehold, you have to have the certainty of term. You have to have the exclusive occupation of the property. Let's begin then with certainty of term. Certainty of term simply requires that a lease have a fixed and knowable starting point, as well as a fixed duration in time. Now, if there is certainty of term, it doesn't actually matter if the parties fail to meet the end point. So if they decide instead to break the lease at an earlier point, because there are various different ways in which the termination of a lease can take place, which we will get to in future lessons, that's irrelevant. It doesn't mean there has to be an end goal that we have to reach in order for this to be a leasehold. All that it needs to be is that there has to be a distinct and clear starting point, often a date, and a distinct and clear duration in time. Now, given the fact that most lease agreements will have some kind of break clause for the parties, it means that it would not make sense for this duration of time to have elapsed in order for there to have been a leasehold in the first place. We will get to in future lessons time the nature of certainty of term and the ways in which leases seem to try and bend as much as possible the rule relating to the certainty of term when you talk about things like periodic tenancies. But for now, when you think about certainty of term, there will be a start date. Let's say I have a lease agreement I sign and it says that I'm going to start the agreement on the 1st of January 2024 and it's going to run for an entire year. It's going to run for 12 months. This would therefore mean that I know that there is a certain directly certain endpoint. This is, of course, the 31st of December 2024. That does not necessarily mean I move out on the 31st of December. I might break the lease earlier on, owing to a number of different reasons. I may agree to extend the lease, which often takes place, given the fact that landlords will often don't want to spend lots of time putting their property up for sale or up for rent, and having new agreements made, having people move in, move out, and all this kind of stuff, and doing certain renovations therein. They would prefer to just have their property making the money for as long as possible, for as much as possible. Equally as well, tenants probably, given the nature of their particular settings and circumstances, would probably prefer it if they had the ability to extend their lease if they so chose. So that is also an option for individuals who have leases, who rent, for example. The next idea is this idea of exclusive possession. Exclusive possession requires the ability to show that the parties, i.e. the lessees, are able to exclude all others from the property. Remember, when we think about exclusive occupation or exclusive possession, and when we think about the leasehold estate, it is a proprietary interest. It is, for all intents and purposes, as strong as a freehold interest. Okay, it is as strong as a freehold interest in terms of at any one time. The difference between a freehold and a leasehold is the certainty of term. It is the duration of time in which you actually have access to that property. You can exclude all others from the property if you are a lessee in a leasehold agreement. This also includes the landlord. You can exclude, theoretically, the landlord from your property if you have exclusive occupation, which is, of course, a requirement for a lease. As I've mentioned earlier, this distinguishes a lease from a license, and the idea of certainty of term distinguishes a leasehold from a freehold. This is how we get these different types of exclusions. So the idea of payment of rent, as I mentioned, the third requirement in the Street and Mountford list, is a little bit more complex. So the case of Ashburn and Salt versus Arnold from 1989 actually rejected the view that this is a requirement for the existence of a lease. So whereas exclusive occupation and certainty of term are necessary in one way or another, there's obviously differences when we talk about the different kinds of leasehold agreements related to certainty of term, but nevertheless they are still required. The idea of payment of rent is a little bit more flexible. Ashburn and Salt and Arnold made that very, very clear. While not necessarily a requirement in the sense of the other two being representative requirements, i.e. necessary requirements, it is still nevertheless almost a de facto requirement, going to the fact that it is a very, very, very common feature of a leasehold. It is probably, there's not very many leases that don't have any kind of exchange of payment, whether that be a payment of rent through money or whether it be a payment through other kinds of things like property or whatever, or anything really. That is still a very common feature of a lease, and so therefore represents a common characteristic of a lease that you might find in problem questions. So in the previous lesson, what we did was spend a little bit of time talking about the various different characteristics of the leasehold estate, talking about the various characteristics as defined in the case of Street and Mountford. We noted specifically that there were mainly 3 characteristics for the existence of a lease. Now, the third and final of these characteristics is one as a result of the case of Ashburn that didn't necessarily meet the same kind of requirement standards as the other 2, but it was at least the case that the other 2 were necessary requirements for the existence of a lease. These requirements were, of course, the certainty of term, as well as the idea of exclusive occupation or exclusive possession of the property. We also noted that there is certain irregularities, if you will, when it comes to the idea of certainty of term, owing to the fact that there are various different ways in which a leasehold agreement can actually be established. There are different types of tenancies that exist, and these may or may not stretch a little bit the definition of certainty of term, such that there is a little bit of discrepancy and a little bit of a conversation we need to have. That is going to be the topic of this lesson. We're going to talk about certainty of term in a little bit more detail. Noting, okay, we've introduced the essential characteristics of a lease from the previous case. We noticed that these were the 3 main characteristics, the final one not being as essential as the first 2. This lesson, as I said, we're going to look at the first of these, the idea of certainty of term. So, what certainty of term generally requires is that there is a fixed start date to a lease, as well as a clear duration of the tenancy. The example I used in the previous lesson is what I will use today as well. If I were to rent a property, I may say agree that I take control of the property, i.e. my lease begins on the 1st of January 2024, the start of the year. And we may have agreed with the landlord or the letting agency that is operating as an agent on behalf of the landlord that the lease be valid for the duration of a single year. This is certainty of term. It is clear when the date starts. It starts on the 1st of January 2024. There is a clear duration and time period in which this tenancy takes place as well. It is valid for a year. So it gives us an indication, a very clear indication, in fact, as to when the tenancy will end. If it's valid for a year, it means it'll end on the 31st of December 2024, at the end of the year, 365 days away. Or 366 days away if we are doing 2024, given that it's a leap year. So, what are the difficulties with this particular area? That seemed like a pretty easy way of understanding it. That was a very easy example of a basic leasehold agreement that can give rise to a certainty of term. Those kinds of examples aren't controversial, as you could probably imagine. If there is a lease that begins on one date and it lasts for a specific period of time, then it means that we have a clear certainty of term. We have a clear amount of certainty as to when the lease begins and when the lease ends. We can, as I mentioned in the previous lesson, terminate the lease at any point throughout that, often with a break clause within the leasehold agreement. Or we could theoretically negotiate for a longer leasehold agreement that maybe extends another year, or maybe extends another 6 months. That's something that can take place, but at least at that point, the leasehold is fairly certain as to the term. Often, though, the difficulty will arise in circumstances where there may not be this kind of level of certainty as to the terms of the agreement. This can be with the use of what are known as periodic tenancies. So, we will get onto the different types of leases in future lessons, and we will touch on periodic tenancies in those as well. But for now, we need to talk about it with reference to the certainty of term, or should I say, more likely, the uncertainty of term. Periodic tenancies will have certainty as to the beginning of the agreement, so the start point is often always firmly certain. But then they will roll on from month to month until the tenants will give notice to quit. This will often be stipulated as requiring 1 month notice, maybe even a little bit longer, but this is of their intention to leave the property. What this essentially means, therefore, is that there will be a specific start point, and then it will just continue to roll 1 month after the other. The continuation of the tenancy will carry on from 1 month to the next, or even it could go for a bit longer than that. It could go for every 3 months or every 6 months. But then the point is that you give notice to quit at a previous period before the end, before the end at which you want to actually leave. So let's say, for example, we have a periodic tenancy that essentially rolls on from month to month, and I want to leave in August. I would probably need to give notice to quit in July, which gives them a month to be able to actually come about the conclusion of that leasehold property. The problem here, though, is that there isn't necessarily a clear amount of certainty as to the end result of such a tenancy agreement. It could theoretically run for 6 months. It could theoretically run for 6 years. Given that there's no problems between the tenant and the landlord, what is the ways in which this could actually be quite problematic? What are these ways? Well, the case of Maxfield Housing Cooperative versus Beresford from 2012 gives us an indication of how the law treats this type of tenancy agreement, because they do sort of word it in a different way that leads to a conclusion that is potentially satisfactory for our essentially being able to fit the idea of a periodic tenancy into the basic characteristics that we cite in Street and Mountford. This was a case where we have a tenancy agreement which was in place between the claimant and the defendant, which operated on a periodic basis. So it operated on the basis of month to month. According to a specific clause in the tenancy agreement, it was clause 6 specifically, there was the ability for the landlord to re-enter the property, but only on certain and limited conditions. In order to avoid this clause and to get the tenant kicked out of the property, the landlord sought to argue that the agreement in fact was actually void entirely because of the lack of certainty of term. So they had an agreement, but then they said, well, this isn't actually a leasehold agreement. We don't have this agreement. The clause is therefore invalid. I can get in and get out whenever I want because the agreement is void, because there isn't a certainty of term. And so as a result of this, it cannot be a lease. The Supreme Court held that there was no uncertainty of term in relation to the lease, since it ought to be converted to a lease of term of 90 years, according to Section 1496 of the Law of Property Act. This would essentially represent a tenancy as a lease for life. And so how this really operates is, rather than representing a periodic tenancy as being a lease that rolls from month to month to month to month to month, it is considered that essentially what this is a leasehold that lasts for 90 years, which is just given a relatively arbitrary long period of time in order to essentially be realistic in terms of how long it could even possibly last for. And then there is a notice to quit given at any month before your intention to leave the property. So rather than viewing this as a tenancy agreement that rolls on from month to month to month, where there's a lack of certainty of term, in fact, the House of Lords, the Supreme Court concluded that there was a certainty of term. The certainty of term was just for 90 years, and there was a notice to quit prior to that if they so chose. So in terms of practicalities, in terms of actually understanding this agreement, it makes no difference whether or not you view this as a periodic tenancy where it's almost like a new lease is created every single month, or it rolls from month to month, or whether you view this as a lease that lasts for 90 years, but you have the ability to give notice to quit 1 month prior. In terms of the practical application of this, in terms of what this actually does for you as a landlord or as a tenant, it makes no difference to the periodic tenancy. What it does do, though, is it fits the idea of the periodic tenancy into the certainty of term requirement, which is obviously a necessary characteristic of a lease as per the case of Street and Mountford. In this lesson, we're going to carry on talking about the concept of the leasehold estate, focusing still on the concept of the various different characteristics of a lease as defined in the case of Street and Mountford. This lesson specifically is going to concern itself with the concept of exclusive possession in relation to the lease itself. Now, fundamentally, as a basic introduction to this topic, in the previous lesson, we spent some time talking about certainty of term as being one of those major characteristics, or at least an essential characteristic of a lease. We spent some time talking about the problematic areas therein, especially when it came to the idea of a periodic tenancy. This idea that rather than there being a specific start date and a specific duration, and then as a result of that a specific end date, you have the idea where you have a roll-on process where maybe each month there is a renewal of the tenancy agreement or something of that kind of nature. And we've talked about the ways in which the courts have been able to get around that little problem, which is considered to be obviously a major characteristic of the leasehold estate. This lesson is going to talk about the next essential characteristic. Remember, there are two major essential characteristics and then a third characteristic which used to be considered a major characteristic of a lease but is no longer as seen as so essential, obviously the payment of rent being that characteristic. But the next characteristic is this second one here, the idea of exclusive possession. Obviously, exclusive possession is a major characteristic of the leasehold estate. And I'm going to refer straight away to the 1988 case of AG Securities versus Vaughan. And in addition to this, the other case which is cited here. I'm not going to try and pronounce the first word, the first name in that case, A versus Villiers, because I'm not even going to try and embarrass myself when trying to pronounce certain words that look just even a little bit challenging. I've done this in the past where I've tried to pronounce complicated words, or even words that aren't even necessarily that complicated but just look a bit scary to me, and so as a result I'm not going to embarrass myself further. This was a pair of cases, two cases, in which the issue of exclusive possession was fundamentally at the heart of the question for the courts, at the heart of essentially determining whether or not some property was a lease versus a license. Now, this is really where the majority of these cases concern themselves. The majority of the cases, or at least the major authorities on the characteristics of a lease, where they concern themselves where there is a dispute as to whether or not the agreement in question is a lease on the one hand or a license on the other. In the case of AG Securities versus Vaughan, for example, the landlord had attempted to terminate an agreement on the occupation of property with 4 tenants living inside the property. Now, the tenants argued that such a termination would be contrary to the basic law which protects lessees. Of course, there being quite significantly more legal protection if you are somebody who holds a leasehold rather than somebody who just holds a license. And so, in order to suggest that this would be contrary to the basic laws protecting lessees, they had to make the case that the agreement in question was in fact a lease. In A versus Villiers, the landlord also wanted to see the removal of a number of occupiers from their property. The two occupiers, in fact, in this case, had identical agreements which used the words licensor and licensee, and this therefore was argued by the landlord gave the authority to permit others to use the rooms at their discretion, again owing to the fact that there is less protection for a licensee over that of a lessee, somebody who is leasing a property. So, two cases here where we have examples of trying to determine whether or not some property was a lease or a license. Remember, even if the word license or licensee or licensor is used in a particular agreement, that doesn't necessarily preclude it from becoming a lease and from it to be determined to have been a lease. That's a point that we've referenced at various different stages throughout this series of lessons. Now, it was held that a tenancy will be created in circumstances where the legal requirements to satisfy a tenancy are present. Again, this is the case regardless of whether or not they had intended for the agreement to be a license or not. And so the results here mean that the facts will prevail where the language of the license contradicts the reality of the lease. That's if you're going to take any quote from the revision of this lesson, take that quote. Facts will prevail where the language of the license contradicts the reality of the lease. Fundamentally, if it is in reality, in fact, a lease, even if it is in language and written down to be a license, facts prevail over that particular language of the license. In addition to this, it was held that exclusive possession was not able to be determined in the first case, given that there was an independence in the agreements of the 4 tenants. If the 4 tenants were jointly able to enjoy exclusive possession of the property, then there would be the satisfaction of the 4 unities, which is of course something that we've noted previously when we looked at co-ownership of land. The reason why we could not satisfy the 4 unities in that case was because the time element had not been present, owing to the fact that they had moved in on separate times. So the unity of time did not actually exist in that first case. So a lease was not found in the first case, but in the second case, a lease was found. The couple in the property jointly paid the rent and enjoyed exclusive possession of the property. So even though there was a clause in the agreement which uses the word license, and it gave the landlord the right to allow others into the property, again, facts will prevail where the language of the license contradicts the reality of the lease. And so even though it was using the language of license and licensor and licensee, it doesn't matter if the facts betray that reality. Finally then, a more up-to-date case of Stewart and Watts from 2018 was a case concerning a charity that was established to provide housing to elderly women, poor elderly women. They had allocated some property to the defendant. The letter of appointment that was used stated that the defendant was not a tenant, and they reserved the right to remove the tenant on the basis of any kind of misconduct or breaches of the agreement that was established. This case involved the charity, the claimants, seeking to remove the defendant owing to the fact that the defendant had enacted or engaged in some antisocial behaviour. The courts granted a possession order, at which point the defendant argued that there was a contravention of her rights as a tenant under a lease. Again, remember, the rights of a lease, the rights that exist under a lease, should I say, are far stronger, or at least stronger than the idea of the rights under a license. The appeal would be dismissed, and this was because a lease was not found to have existed in this particular agreement. The reason for this is because the agreement, did not grant exclusive possession, but they granted exclusive occupation of the property. And so there was no ambiguity between the facts and the texts, given the fact that it was seen to be a license, it was stated as being a license, which is of course the text, the language of the agreement, but it is also factually a license, or at least factually could not have been a lease, because it did not grant exclusive possession, but only exclusive occupation. Welcome back, everybody, to our studies in land law. We are continuing talking about the nature of the leasehold estate, focusing on this idea of the various different types of leases. So I did mention that we were going to do this at a point eventually throughout this series of lessons. Previously, what we've done is talk about what are the essential characteristics, what are the requirements for the existence of a lease. We noted that there were two main requirements, of course, the first being certainty of term, and the second being this idea of exclusive possession. We then discussed both of those in more detail in their own separate lessons, and now I said that I was going to get on to looking at the different types of leases, and now that's what I'm going to do. We're going to talk a little bit more about this. Essentially, it's an element of the topic of leases we've briefly examined, but we are not yet properly unpacked. I know that says property unpacked, which is quite ironic given that we're doing land law, for it to be that, but what I mean is properly unpacked. This is essentially the different types of leases that exist and how they link to and relate to the basic requirements for the existence of a lease. So when you go through this lesson and you're looking at the different types of leases that can exist, think back to those previous videos that we've done, the previous videos where we've talked about the characteristics of a lease, and think, okay, how does this type of lease operate in a way that is concurrent with and that is incompatibility, that is compatible, should I say, with the idea of the characteristics of a lease that we looked at previously. The first and the easiest to understand type of lease is called a fixed term tenancy. The most basic, the easiest to understand type of lease. There will be an agreement to take on the property as a tenant for a period of time. This taking on of the property gives the tenant exclusive possession, satisfying one of the characteristics, and that is for a period of time, satisfying the second characteristics, obviously that being the idea of certainty of term. There'll be a beginning date, there'll be a duration, and as such, there would be an implied end date, at which point the tenancy will end. You can have often a clause within a fixed tenancy which allows for the termination of the leasehold prior to the end of the period. This is through the idea of, for example, a notice to quit, a notice to break your lease, for example. Or there are also potentially clauses within a fixed tenancy agreement that allows for you to extend the leasehold, to extend and go into another period, and to maybe renew your tenancy agreement, or maybe have a new tenancy agreement drawn up. Remember, landlords and letting agents, okay, want to keep their tenants, so long as they're good tenants, of course, in their property for as long as possible. Because if they leave the property, then there is a period of time at which you have to essentially try and find a new tenant, which is obviously time that is being wasted not having a tenant in the property and not having a tenant paying you rent. So sometimes that can take months. And so as a result of which, it is always beneficial and advantageous for landlords and for letting agents to try and negotiate longer tenancy agreements, maybe renewing a tenancy agreement such that they can keep their good tenants that they like, presumably, in the property for as long as possible. Alternatively, if there is a breach of a covenant, we'll get to what covenants are in future lessons, the landlord may be able to forfeit the agreement through the process of forfeiture. We'll get to how this works when we look at termination of the leasehold estate in a future lesson's time. The second type of leasehold agreement that can exist is one that we have also looked at in the past as well, which is the idea of the periodic tenancy. A periodic tenancy will operate on a rolling basis. Essentially, there will be often a fixed tenancy duration of time, often a month, maybe 3 months, maybe even 6 months, okay? And that this will automatically recur on a month-by-month basis. As such, there is not necessarily an end date in the same way as a fixed agreement, but where there is a desire to leave the property and end the tenancy, there is a requirement of a notice to the landlord. This will often be on the basis of the duration at which point the periodic tenancy renews. So if it is a month-on-month rolling basis, you'll probably have to give a month prior notice to the fact that you are leaving the property. If it's 3 months, 3 months, or it could be a month. It could be a month rolling basis, but you might be asked to give 2 months notice, given the fact that depending on what is in the agreement. Although standard agreements tend to be for the duration of that period in which you have that rolling basis, will be the period of notice that you should really give. We remember previously that this can be satisfied. We can satisfy the certainty of term requirement in this case by thinking about this not necessarily as an agreement that renews on a rolling basis every single month, but rather as a fixed term tenancy of 90 years with a clause that is within the agreement that gives notice to quit at a month with a month's notice, so that fundamentally, in fact, it makes no difference to how it operates, but then in law it fits into that nice, easy certainty of term requirement that is necessary for the characteristics of a lease. Another type of tenancy is a tenancy at will. This is a type of lease whereby the tenant is able to take exclusive possession. Okay, obviously this is something that is required for there to be a leasehold estate, but owing to the personal relationship that exists between a tenant and a landlord, and owing to the nature of the agreement, either party is able to terminate the agreement at will. This may then be transformed into a periodic tenancy if it is implied through the payment of rent and the intention of the parties. Again, the ones that we're looking at now are far less common in any kind of agreement, but they just exist in law as possible types of leases that can exist. The fixed term and the periodic tenancy is what you will be dealing with for the most part when you if you already do rent, or if you decide to rent after university or after whatever studies you do, and if you ever go into this area of practice in terms of being a property lawyer, for the most part, if you're dealing with leasehold estates and disputes and stuff arising out of a leasehold agreement, you're most likely going to be dealing with the first two types of agreement. These are just other types that can exist. In addition to this, a tenancy at sufferance is where the tenant remains in occupation of the property after the expiry of an ordinary lease. If this happens, and the landlord neither consents nor really fails to consent to the occupation, the tenant enters into tenancy at sufferance until a new agreement is made. Essentially, what this does is it gives rights to those who are in occupation of the property while technically not allowed to be, owing to the failure of renewal of a new agreement with the landlord. So the way this fundamentally works is, if, let's say, there is a tenancy agreement that exists and the end date for this tenancy agreement is I don't know, May the 26th. May the 26th of this month, let's say, is coming up. And then what essentially this means is that if that time then elapses and no one really says anything, the landlord doesn't really care because maybe they're still getting their rent money every single month, and the person in occupation doesn't really care because they want to stay in the property, then they enter into a period known as a tenancy at sufferance, because essentially what this does is suggest that it will not amount to a trespass owing to the fact that the initial tenancy agreement was lawful. So you don't automatically become a trespasser, it turns into this idea of tenancy at sufferance instead.